why has there been felt the need to change the law? Obviously, a lot of it goes back to Grenfell and the situation we had there where the doors failed catastrophically, as we realise. Number of reasons, really, due to the lack of preventive maintenance, damage, and poor specification. And also, some of the original doors were still in the building, which actually, curiously, never actually met the building regulations of the day even, but nobody actually picked that up. But anyway, so there's the importance of fire doors within a building, within part of the compartmentation, is they form a major element of protecting the public. So that's why these particular regulation 10 has been brought into play, so that we can focus particularly on those. It's now a legal requirement to, in simplistic terms, undertake quarterly checks of all fire doors in the common parts, as your cross corridor doors and general communal doors. A best endeavour basis for annual checks on flat doors, which is obviously one of the more challenging areas of checking, inspecting doors, is the actual getting into every flat entrance. I mean, there is suggestion in the regulations that we could actually use legal powers to actually be able to gain access to flats, but it obviously means there's a lot of work involved. You can go to a block of multiple flats and you'd have to visit several times in order to gain access to every door. So what they put down is a best endeavour. Information for the residents, pretty simple really. It's really just stressing the importance of a fire door, stressing that it should be kept shut when it's not in use, not to tamper with things. You know, it's difficult, these door closers, particularly for the more infirm persons, elderly. Door closers get in the way, especially when they're trying to bring their shopping in. And we see many a door closer arm removed by a good meaning member of the family, just to make it easier for someone to actually access their flat. And then obviously the point of reporting things if something does go wrong, because it is possible that things will fall off because they're not properly maintained. It could be the closer stops working properly because it's lost its oil, those sort of things. Stress the importance of reporting that back into the responsible person or their agent.
We were tasked in July, around July probably time, when we first saw the draft of the new Fire Safety England regs when they came through. We realised quite quickly there was a potential concern for fire and rescue services, especially regarding Regulation 11, which was the digital transfer for RPs to passive or local fire and rescue services regarding the plans and external walls, and also Regulation 7, which is the reporting of faults of essential firefighting equipment and lifts and the rectification of these faults. We have to understand where these regs have come from. They obviously come from the findings of the Grenfell Tower inquiry, and it was all about making that better information coming to the fire and rescue service so we can adapt and deal with an incident a lot better and plan for incidents better. So the information is very much required, and all the regs in themselves have that, you know, are through the findings where there were failures or faults with the RPs understanding the safety of their building.
So it applies to all residential buildings with 2 or more domestic premises with common areas, and the applicability of the new regulations is tiered and will depend on the height of the building. And when we talk about height, it's important to recognise we're focusing on the height of the top storey, not the roof. So most of the regulations only apply to what we define as high-rise residential buildings, HRRBs, which are the buildings at 18 metres plus or with 7 storeys or more. And these are the ones that we want to focus on today. And that's not because I think these are any more important than the other regulations, but these are the ones that have specifically been introduced to I suppose, assist and improve fire services responding to incidents in these buildings kind of going forward. Regulation 4 requires the responsible person to provide a secure information box. For those unaware, secure information box is just the, is it the new name? But it is the name for what you previously referred to as a premises information box. That they are one and the same. The SIB must contain contact details for the responsible person and any body who the RP permits access to their building. For all other buildings, this will be one and the same. However, you can imagine scenarios where we've got freeholders, managing agents, facilities management companies, where hopefully you can appreciate where the need for this comes from. The SIB must contain building and floor plans that are required elsewhere in the regs. And the regulations also state that the SIB must be reasonably secure from an unauthorised access and vandalism. Copy of the plans must be kept in the SIB so that they are accessible to firefighters in the event of a fire scenario. And recognising what does go on in the event of a fire, the level of activity, the conditions. It's why we would ask for plans to be A3, that bit bigger and easier to see than your standard A4, and that they could be laminated so that they are still usable after a few minutes when they've been subjected to dropping on the floor, splashed with water, stood on, and all that sort of stuff. What we can see there is an example of the quality of the plan we would expect to see. Clear, simple. The regulations state that where we've got floor layout, where the floor layout is identical on, I suppose, first of all, just to clarify, I suppose the bits that are what the plans must indicate is just shown on the slide, which you can read there, and that's prescribed in the legislation. But the legislation also does allow for where you've got multiple floors with the same layout, then a single layout, a single plan may be used to represent the multiple floors, providing you indicate what floors they do represent. The official Home Office guidance, which is, we've got a little screenshot of that on the left-hand side, does provide a link to the NFCC website, which, for want of a better word, is a portal that brings together the links to the information sharing pages of all the fire and rescue services in England. And now that the regs have gone live, for each fire service has now got in place a method for receiving this information. Wayfinding signage needs provided on stair landings and the outside of lifts for firefighters to indicate what floor you're on and where flats are. Now, again, as I remind you, it's there just to assist firefighters. It's not replacing anything that's already required to assist people in getting out of the building. But just I suppose just to bear in mind what the issues that we're trying to address, like common issues such as flat numbers that don't align with the floor, or how lower ground floors can affect reference to floor numbering, etc. This has been a requirement in ADB now for a couple of years for buildings under 11 metres, and now we're just kind of seeing that now reflected for existing buildings of 18 metres plus.
The fire safety regulations, as has been noted by the previous speakers, is born out of the regulatory reform order. And as we know, the regulatory reform order has also been amended under the Fire Safety Act, so that we now have to look at external wall systems on buildings with 2 or more residential dwellings, as well as looking at fire doors generally, in order to ensure that they are safe. And that is the overriding and principal function of the regulatory reform order, is to make sure that the building is safe. So when we talk about the fire safety regulations, in particular the new obligations imposed on buildings above 11 metres in height to check fire doors, to flat front entrance doors, as well as communal fire doors, we have to bear in mind that this is all about making sure that these elements of the building are safe. Now, in the context of the law, best endeavours requires you to do more than reasonable endeavours, or to do things that are reasonably practicable or reasonable. Best endeavours certainly it requires you to really take all reasonable and proportionate steps. Now, even though best endeavours says what it says, it is still nevertheless subject to qualifications of reasonableness and proportionality, but you have to go that step further. So we all understand that we're going to have to carry out annual checks of front entrance fire doors and all buildings above 11 metres in height. And in order to do that properly, we're going to have to get access to that building. If one looks at the fact sheet, which has been updated on the 19th of January, just a few days ago, what it says about best endeavours is this: it will be for responsible persons to determine the best approach to engage with residents in order to get access to undertake the annual checks of flat entrance doors. This could include the responsible person agreeing with residents a date so access can be granted. Now, that's all lovely and all very well, but as we know, having acted in many cases where access has not been easy to get, and whether it's in relation to gas safety checks or other things, in any significant building where there is a mixture of tenures, whether it's leasehold, private ownership, or tenanted properties, there are going to be numbers of properties where there is going to be difficulty in obtaining access. And so the question arises in those circumstances: how far do these regulations require you to go? Well, one of the questions that we asked the government directly was, well, is this going to oblige you to get an injunction? Well, the further guidance doesn't say that you have to do that, but what it says is this: it goes further and provides that arrangements relating to access to flats for checking front entrance doors will need to be made with the leaseholders. And it goes on to say this: in the event of an impasse, a court order can be obtained for this purpose, i.e. the purpose of obtaining access. It is recommended that any new leases include a right of access. Well, even if your lease includes a right of access, if a resident is refusing to give it to you, then you may need to obtain an injunction to get it. And of course, the Building Safety Act, for those of you who have read some of the provisions that have yet to come into force, will in due course contain a right for a principal accountable person or accountable person to obtain an order from the court to obtain access to a residential property for a fire safety related or structural purpose. This year is going to be an incredibly busy one from the point of view of fire safety legislation. We're going to have most of the substantive parts of the Building Safety Act come into force, so the gateways and all of that stuff. We're also going to have various attendant bits of legislation come into force as well. So we're going to have new regulations about competence and other things. So there's going to be a lot of stuff to talk about. But you know, most of you will know about all the stuff that's coming into force. We also have, of course, the Fire Safety Act, which is rather flown under the radar a bit. I mean, we're now beginning to see external wall fire risk assessments carried out in accordance with PAS 998 as one methodology for assessing the safety of those external wall systems. And, you know, that's thrown up a number of issues that may need to be addressed in a more a slightly revised version of PAS 998. We're seeing a very significant inconsistency in opinion across the fire engineering community when looking at a very similar type of building. But these are all things that will hopefully wrinkles that will flatten out as we move further into 2023.
Can the panel give views on safety case reports and how do they differ from an FRA? Or I guess you guys at the NFCC as well can weigh in on that one.
Well, safety case reports are an entirely different document, because a safety case report, when they are called for or required under the Building Safety Act, will need to obtain all sorts of information. The regulations that are going to tell us exactly what they need to contain have yet to be published, but it's going to require design information, it's going to require as-built information, and it will also require, no doubt, fire risk assessments and other things as part of that overall body of documentation. So I think the answer to your question is that fire risk assessments, where they're undertaken for the purposes of these regulations, the Fire Safety Act or a general fire risk assessment under the RFO, will need to be included within that document.
The actual clarity on safety cases isn't very clear yet, to be fair. We have been trying to work with DLUC and HSE to get that clarification, and we're not quite there yet. So we'll be putting out additional guidance when we do have that clarification.